The University of Missouri Law School had a symposium last summer. Kathy was one of the presenters, and she's written a speaker, which is published in the Missouri Law School Law Journal on this process and processes like this that corporate America is very interested in. Right now, as we speak, there are 2 Fortune 100 companies that are in the process of developing a participation agreement, and they intend, it's a vendor-customer situation, and they want to maintain a relationship. And good lawyers involved, and they know that, if they go to the courthouse, the odds of them having a good vendor-customer relationship are going to be pretty slim. So we'll be excited to see how that comes out. Our colleagues in Boston have had a number of business disputes, and they continue to have clients coming wanting to resolve business disputes in this process. So it's not a passing fancy. It's here to stay. There are just so many areas where it'll work and it makes sense in employment, in probate, in business, in commercial disputes, construction disputes. We just got an article published in the Construction Law Journal in the state of Texas. The construction industry has come out with some documents called the consensus docs. And the article points out the similarities between the collaborative process and working out disputes under these construction docs in the construction industry. So, one area is we just got to get our arms around a lot of different areas, and they're different. You take probate, for example. Well, the state of California, the probate laws are very different than they are in the state of Texas. We have found out for a fact, and in other states. So, as the process develops in areas of laws, it's going to have to be tweaked to meet the requirements of the individual jurisdictions. But as long as the integrity of the process is maintained, it can work in any state, in any jurisdiction, in any country, and in any area of civil law, I think. The process really, there are, I guess you could say there are 2 threshold elements. One is the withdrawal provision. You start with a written participation agreement, the lawyers and their respective clients, and the clients have been fully informed of the process and how it works, that the lawyer, in the event the parties don't get it resolved, the lawyers will be required to withdraw, and they cannot represent their clients in any adversarial proceeding involving the same subject matter. That's key. That's the cornerstone of the process. And another relevant part of the process is the voluntary disclosure of information. No discovery battles. If you needed to make a decision to settle the dispute, then it's put on the table. Those 2 elements are, and it's the same in family law. That's the heart and soul of the process. There are excellent collaborative lawyers in the family arena that insist that you must have a team model. And that's fine. And there are a number of other good family collaborative lawyers say, no, that's not necessary. Now, our view in our organization is that that's not a way to start. That our colleague law professor at Missouri is fond of saying, let the process fit the fuss. And our philosophy is that's exactly what needs to happen. You start out with the lawyers and their respective clients, and if it develops as you go along, it would be good to have a financial expert in there. Or if you've got a construction dispute, it would be good to jointly retain an architect or an engineer. Then do that, but don't start out that way. Our job is to assist clients in solving their problem or resolving their dispute, and that's what and this process does that. You have a commonality of interest with your client in helping to get the dispute resolved, and as you know, lawyers have financial interest in litigation, and with the withdrawal provision, well, that's out of this, because I don't want to lose the client. I want to help the client get the the dispute resolved. And the litigation process over the years, as you know, it has gotten terribly expensive. It's difficult on clients, large clients and small clients. It doesn't matter what your economic status is. And so I just see this, as I said, as a first option. And as I say, it's not for every lawyer, and it's not for every client or every dispute. But if that all fits, it's going to get it resolved. And lawyers, you know, we're not really don't need to be warriors. I mean, a dispute is not a war or a battle to be won, but the litigation process has kind of gotten that way. I may have mentioned Julie McFarlane's book. She's a law professor at Windsor in Ontario, Canada, and very much an advocate of settlement outside of the court in these processes, like collaborative law. And she published a book a year or so ago called The New Lawyer, How Settlement is Transforming the Practice of Law. And the phrase that she coined, I thought was quite clever, and we've used it in writing as the new lawyer as conflict management advocates. Advocating for your client, but advocating that the conflict be managed and the dispute be resolved. And that really ties in with a Abraham Lincoln quote, which I've had on the wall of my office for the whole time I was trying lawsuits. He was giving a lecture to some law students. Discourage litigation. Persuade your neighbors to compromise whenever you can. Point out to them that the nominal winner is often the real loser in fees and expenses and waste of time. As a peacemaker, the lawyer has a superior opportunity to be a good man or woman today. There will still be enough business. I really would like to throw in this quote too. Somebody named Clark came up with Clark's law of revolutionary ideas. Every revolutionary idea in the science or arts or politics or the law, any field of endeavor, invokes 3 stages of reaction. Number 1, it is impossible. Do not waste my time with it. Number 2, it is possible, but it's not worth doing. Or number 3, I said it was a good idea all along. And this is really the naysayers today with respect to the collaborative movement are the same as when mediation was getting started 20 or 25 years ago, and they're saying the same naysaying type things. So the people involved, it's really a mission. I mean, it's a passion to keep this ball rolling. We just need to keep that in mind, that we're here, as Abraham Lincoln said 150 years ago, our job is to be peacemakers when clients have disputes. And that's what's attractive to me about this.